The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We will hear two cases this afternoon. Those cases are State of Iowa versus Mark Martin, and the second case is the estate of David Paul McFarland by personal representatives versus the state of Iowa. We'll now hear the arguments in the Martin case, and Ms. Reindl, you may proceed.
Thank you. May it please the court. My name is Sarah Reindl. I'm here on behalf of Mark Martin. I've never done this before, so I appreciate your patience. I will do my best. I'm going to skip right to it and not focus on things that we've already talked about in the brief or matters that you can read for yourself in the record. Basically, I want to talk about the fact that defense counsels need you to make a definitive and strong decision in this case because we have had it. There are supposed to be two purposes for voir dire. First is to enable the court to select an impartial jury. You'll notice in the trial court's record, at no point does the trial court say, thank you. State, I found your voir dire very helpful. Not at all. In fact, the trial court says, you're testing the gray areas here. I'm not comfortable, but I don't think you've crossed the line, which basically in the real world means it's been condoned, which means that the state can keep doing it and keep doing it and keep doing it. And we'll say to our clients, listen, this is how it's supposed to be, but this is not how it actually is. Next is supposed to assist the trial counsel in exercising peremptory challenges. Just on its face, when you read it, folks, you can see that it's intended to persuade, influence, and prejudice the jury. It fits within the theory of the case that the state is presenting, which is that the law enforcement are going to be fact witnesses. They are also going to be experts. They are also supposed to be the people that, at least in this case, that tell the jury what it is that they're actually hearing. So they're fact finders too. That's how this case was set up. And that's why the state's voir dire fit into that theme and is absolutely patently improper.
Counsel, let's just assume for the sake of discussion that some of the questioning crossed the line. I'd like you to focus on the prejudice that you claim resulted here, and specifically to focus on the question of whether we have really a harmless error situation here, given the evidence, the relative strength of the state's case with the testimony of the informant and the recorded audio recording of the transaction. I mean, was there really any prejudicial error that resulted here if the state in fact crossed the line?
Yes, Your Honor, I believe that there was, and for several reasons. First of all, the purposes of voir dire set forth in State v. Windsor are supposed to apply equally to the state and the defense, right? And what this court has done, what the appellate court and the trial court has done, has put another burden on the defense, which is to undo the damage that the state did in its initial voir dire process. That creates a whole other category of effort and damage control that the defense needs to do. And that's not listed as one of the purposes of voir dire. So you're putting another hurdle, another burden on the defense, which is to undo the damage that was done in voir dire initially in prejudicing the jury, right? And you're saying, boy, I hope they have a really good defense counsel. And I'll tell you, most of us, we're really got our hands full with the facts, the law, and witnesses, okay? And the other point is that I would argue, Your Honors, that when a state's attorney goes before the jury and says, my job here today is not to uphold and protect the integrity of what this court has said voir dire is about. My job here today is to see how far I can push it, how far I can go until I've crossed or
let's talk about some of the specific
yes.
questions that were at issue. One of the areas that's raised is this questioning of one of the jurors who apparently used to be the girlfriend of one of the state's witnesses, one of the deputies that was involved in this operation. And I think you would agree that's a legitimate area of inquiry in voir dire, right?
Yes?
And I mean, perhaps the question could have been asked in a non-leading, more open-ended way, but you would agree that that's a legitimate area of inquiry, right?
Yes, but I have a response to that. Because although it's a legitimate area, when it was asked, oh, so he's a credible guy, or however it was worded, I think...
Good guy, I think.
A good
guy.
guy
When you knew him.
And you couple that with him saying previously, and this is appendix page 49, oh, and okay, so obviously they're good, hardworking people, right? And you talk about the safeguards in terms of credibility, public accountability, the state's attorney worried about being, reelected, that they're just these good guys trying to do their jobs. What you've done then is you've set that up to the point where that has a different meaning and a more complex meaning to that juror, because that...
Well, you're kind of moving into another area, which was the questions asking about the, which of you voted in the for the county attorney office, and I would tend to agree with you that's improper, but there wasn't any objection made below to that line of questioning, right?
I believe that the record reflects that the defense attorney approached the bench several times. That's on page 61, and then also moved for mistrial based on improper voir dire.
But without mentioning that, the bench approaching, that was later on when the prosecutor is asking, I think, one or more potential jurors, imagine you're a drug dealer, which seems to me kind of a clumsy voir dire. I mean, it's not the kind of voir dire I would want to do if I was trying to get a jury sympathetic to me.
I think
you see my point?
I do, and I think that really what it boils down to is that juror was being asked to personally vouch in front of the rest of the panel about the credibility of a future witness whose testimony the state was going to rely on as a fact witness, an expert witness, and ultimately a fact finder to tell the jury what it meant when they were talking about a Yahtzee game. So what I'm saying is that there are many levels and many pieces that fit together with a theory of the case or a improper use of voir dire in terms of strategy, which was to persuade, influence, and prejudice so that there was a greater likelihood of conviction. And what I really am trying to say is that if this court does not want to uphold the true meaning of voir dire, the purposes behind it, and we want to squint our eye, tilt our head to the side and say, yeah, I could see where that might make sense, then we might as well just take it out and just say, you know what, the standard really is, in practice, is whether the ends justify the means. If it gets us a conviction, then, and you did what you needed to do to get that, that's fine.
Counsel, can you cite some cases where other courts have concluded that similar lines of inquiry during voir dire have crossed the line?
Well, the cases that I relied on in my brief really talk about the purposes behind voir dire, and I would rely on those and the sites within those cases, which would be State v. Hunt, State v. Windsor, State v. Tubbs, Mumin v. Virginia, and State v. Clark. Because, like I said, in the real world, when we talk about using voir dire to set up a case, rather than to make sure that the case is going to be heard by a suitable and impartial jury, then what we are doing is taking away the integrity and purposes of voir dire and saying it is yet another opportunity and should be used as another opportunity to prejudice, inflame, argue, persuade the jury. But our system and what we've said really matters is that this is not the time for that. Voir dire is the time to help the court select an impartial jury. The trial court does not say that this voir dire that existed in this case by the state accomplished that goal. The second thing is to help in exercising peremptory challenges. These comments about, oh, he's a good guy, or civics lessons about how, they're to uphold and safeguard and ensure that the evidence that the jury hears is credible, at the risk of losing their job, did not do that. And I don't know how better to argue a negative when you can read for yourself and you can see how it fits within the theme of the case, that this was improper voir dire. And when we say, well, yeah, but it didn't result in any harm, Your Honors, I say that the fact that they were pushing that line as the real purpose causes harm in the first place. The fact that you're putting the burden on defense counsel to try to undo that, to try to fix that prejudice is harm, because then there should be three purposes for voir dire for the defense counsel. You know, help the court, use peremptory challenges, and undo prejudice and harm that was created by the state. And that certainly wouldn't be fair. The other thing that I think...
guess I want to just interrupt a little bit there, and I thought, since I've written down that same word, the voir dire by the state to me is so clumsy and awkward. It really doesn't create the harm that I think you perceive that it does. I didn't get the gist through the course of reading the entire transcript of jury selection that this was really an intentional thing. It really seemed to me to be more awkward. Then, of course, you talk about the burden of the defense counsel to have to respond to it. You know, I thought Ms. Flander just did a tremendous job, exactly what you had to do. She didn't have to go above and beyond what I thought a defense attorney would have to do. She just did what I consider to be an exemplary voir dire for a defense attorney. So where is the prejudice here? It's awkward, it does go up to the line, it's pretty bad, but I just don't know that there's any level of prejudice here when I need to defer to what the trial court was observing and watching here.
I'm with you, but I think that the answer and the problem with what happened here is actually in your question itself, okay? Because when the state approached that jury and didn't have those two purposes in mind, but rather its purpose was to see how far it could go, what arguments it could make.
Well, I guess that sort of begs the question for me too. I mean, is that really what you perceive this, you know, I don't know this prosecutor, I don't know the history. It sounds like from the record he's been doing this for 4 years in Cerro Gordo County. But do you really think that's what he was doing, is pushing it to the extreme just to see how far he could get away from this, when you have, as we said earlier, you've got a confidential informant, you've got a recording. I mean, this is a pretty strong case. Why would you use this case to push that envelope, so to speak?
And I think that the answer to that is on page 66 of the appendix, when he says, first thing, well, if I did cross a line, it didn't cause any harm, okay? That's it, right there. Because he says, okay, so yeah, I might have, you know, maybe gone too far this time, but it didn't cause any harm. And what that does is that creates the burden on the defense, okay? That puts the burden on the defense, which is not fair. It is not just. It does not uphold the integrity of the voir dire purpose. And I may not be saying this as artfully as you gentlemen can. When his first response is to say, yeah, if I did cross the line, it didn't cause any harm, he's acknowledging that he may have done wrong. And the fact of doing wrong or having the intention of doing wrong or pushing or testing that gray area, instead of having the two noble purposes of voir dire in mind, when you start out on your task, which is the voir dire process, is inherently wrong.
Counsel, it sounds to me like your position, if I may try to rephrase it.
Could use the help.
What I hear you arguing is that if the state crosses the line in voir dire, we should view it as a structural error rather than looking for actual prejudice. Is that really what you're arguing?
I'm saying that when the state crosses the line, prejudice is inherent, and the court manifestly abuses its discretion by not holding the state accountable and by relying on the exemplary ability of a defense counsel to undo the harm. You've then created another purpose of voir dire, which is not consistent with the court's ruling in State v. Windsor and more recently acknowledged again by State v. Hunt in 2011.
Should the defense counsel have been more active in objecting and trying to head this off at the time?
Well, I believe that the defense counsel objected and approached the bench and interrupted and did what she needed to do to preserve the error. I agree with the appellate court in that respect, that she did in fact preserve error. She also has to remember that as she's objecting, and this is her first time and before the judge, and before the jury, sorry, not the judge, the jury, that she has to be cognizant of the impact that those objections will have on the jury and how they'll perceive her in the case, whether she's an obstructionist or not. And my point is that she should not have to do this here. We should, if you make that line, if you say, wait a minute, this, you didn't just teeter. And in fact, your purpose in approaching that line was not for either one of the reasons that have been set forth by the court as acceptable reasons. Prejudice is result.
Does it matter?
Oh, we're reviewing for abuse of discretion. Would you agree?
Yes.
Isn't the trial court in a better position than we are to decide whether there's something more needs to be done, start over or a curative instruction? I mean, the trial judges there can read the room, can observe the reactions of the jurors. Why should we second guess the trial court in this case?
Because defense counsels need you to redraw that line. We absolutely, positively need you to uphold the voir dire process. Because otherwise, the standard truly is, if the ends justify the means, go for it.
Counsel, does it make any difference whatsoever in your analysis whether the prosecutor's conduct was clumsy or calculated?
I would say you're giving him a pass and quite underestimating him by saying it's clumsy. So what I mean by that is that when you look at the theme of this case, which uses the law enforcement as a fact witness, as an expert witness, and ultimately a fact finder to tell the jury what it is they're listening to on this tape, and you look at and you put that in the context of what he did in voir dire, don't give him a pass by saying he's stupid. He's not. He's quite the opposite.
Thank you, counsel.
Thank you.
Mr. Bowler, on behalf of the state.
May it please the court. Before we dig into the merits of this case, we really have to start with the fundamentals, and the fundamentals here at error preservation. The case law in Iowa is very clear that you need a contemporaneous objection to anything that you're complaining about in order to adequately preserve error.
Yeah, that's fine, but again, during the course of a voir dire examination, you're not going to repeatedly object to every single question. And if you did, you know, this would have taken longer than a day. It would have taken a day and a half just to get the jury selected. I think she strategically entered the objections when she could, I think at least 2 or 3 times from my record, or my review of the record in this matter. And you're saying that you don't think that that's sufficient to preserve error here?
I have 2 points I want to make in response to that. And the first is that there are a lot of ways to object during voir dire without making the jury mad at you. We have a defense counsel here where we know that when she did choose to object, way later, when we're talking about the confidential informant, she doesn't stand up and yell objection. She's an experienced defense lawyer. She knows to say, well, Your Honor, can we approach the bench? The jury has no idea what's going on there. There's no reason the jury would think that she's being obstructionist. But to your question about she did a pretty good job preserving error, Your Honor, I don't believe that accurately reflects what we see in the record here. The exchanges that we've been talking about, what's block quoted in the defense brief, happened on pages 38 and 39, 44, and 48 to 51. The first time that defense counsel approaches the bench is 37 pages later. On page 88, more than half an hour has gone by before any objection is lodged in the trial court. And that matters because the point of the error preservation rules is so that we can correct this error. Some kind of curative instruction could have been given if appropriate. The prosecutor could have been admonished if there was error. But instead, defense counsel sat back, waited, and the only time she objects is about the informant.
I'm going to kind of move on a little bit if I could. And let's have you respond to counsel's argument that perhaps we need to start drawing a line when we talk about this. I'm going to presume error was preserved here just for purposes of our discussion this afternoon. And so then if error has been preserved, what about starting to redefine the lines and drawing the lines in a case like this, and getting back to Justice Heck's comments, does it really matter whether it's clumsy or calculated?
I think it does matter. The reality is that trial practice is very hard. Voir dire is especially difficult. Extemporaneous speaking between a prosecutor, defense attorney, and 12 to 64 people they've never met before. Are there going to be inartful exchanges? Of course there are.
But the number one rule when you voir dire a jury is not to proselytize the jury. And that's what this guy's doing, trying to condition them that police never lie.
Your Honor, I don't agree with that. I think what we see here is a maybe ham-handed or maybe sloppy attempt to do exactly what the prosecutor's supposed to. That's smoke out bias. Take, for example, the exchange where he's talking to this person who knows Frank Hodak, who's a deputy sheriff. You could ask that potential juror, is there anything about your past relationship with Deputy Hodak that would bias you favorably or unfavorably and prevent you from being a fair and impartial juror? But of course, we know real people don't talk like that. It's an exchange between a prosecutor and a layperson. One way to ask whether there's a bias is to say, is he a good guy? And if the person had said yes or no, that's appropriate, because we're in an area where the prosecutor is attempting to smoke out whether or not there's a bias for or against the state's witnesses. And that is the purpose of voir dire. That's certainly what this court said last term in Webster. Not every exchange during jury selection is going to read very well. Certainly I've read enough of my own records from the trial court to know that the ums get in there. Sometimes you veer off course. Sometimes you think you're being really clear, and what ends up in black and white is not.
Well,
I agree with Phil.
You agree we're in the gray area?
Your Honor, I don't think we are. I think we're in a sloppy or clumsy or inartful attempt to do the right thing. The prosecutor didn't actually vouch for anyone's credibility. He asked a potential juror whether Mr. Hodak was a good guy. I think it'd be different if the prosecutor stood up and said, I know Frank Hodak, and I know he's a good guy, and you should believe him. No one would dispute that that is inappropriate. But what we have here is the prosecutor trying to get at the heart of the matter. Do you, the potential juror, have a bias in this case? I think the closest to a gray area or a questionable exchange is this dialogue about the county attorney's office. But I want to suggest to this court that if that had been at the beginning of voir dire, we wouldn't be so troubled by it. I think what the prosecutor's attempting to do is introduce himself to tell the jury where he's coming from. The reality is that most of our citizens don't know what a county attorney is. They probably think we have district attorneys like you see on Law & Order. He's trying to just explain to the jury where he's coming from, and he's trying to get to an appropriate area. We see at the end of that exchange.
Counsel, that's certainly a benign interpretation, but isn't it just as plausible to read this series of questions and answers as an effort to enlist the jurors to believe they're on the same team as the prosecutor and the chief law enforcement officer for the county where they live?
And that's exactly why we have to trust the district court judge to make the right call. Looking at this black and white text, you can read, depending on what framing or what lens you're coming from, you can read good things or bad things into any question that's asked during jury selection.
Why is it incumbent upon a defendant to fix up the state's obviously clumsy, we'll call it even clumsy, questioning? I mean, you start, I can see the defense attorney start getting into it, well, do police lie? And so, you're just reinforcing what they said. I mean, why should a defense counsel be required to fix up something that the county attorney goofed up?
I don't think that the defense attorney did go above and beyond to fix or clean up anything. To Justice Ziger's point earlier, I think this is pretty typical of what we see in voir dire, both by the state and the defense. The state's going to ask questions to determine whether there's a bias against law enforcement.
Just to correct, I'm not sure that I see this as part of the state's case, a typical voir dire from the state.
Sure, we'll talk broad terms then, and I apologize for dragging you in here with me, Your Honor.
I agree with him, too. This is not typical.
Your Honor, I think it is. The language might be sloppy. The language might be different than what we see, but the areas that are talked about in this case are exactly what's talked about in every case.
Well, let me tell you why I think the case is kind of unusual, and give you a chance to tell me otherwise. We have this inquiry about, do police officers lie? But in the case, we know we've got a problem substantively. I mean, the prosecution has a problem, if I understand it right, and I invite you to tell me I'm wrong. But so they have a tape, but they got a problem with the tape. And they have a problem at a fairly key moment, I think. We know that the informant comes out and he does have meth. I mean, we know that much, and that's almost undisputed. The question is who sold it. And at the key point, the tape fails to give the kind of evidence that the state desires. And so they have police officers testify to kind of fill the gap. And then you look at the voir dire. Do police officers lie? And you look at the problems in the evidence, and you begin to think, the voir dire was designed to try the case rather than really smoke out a problem. So come at me at any level you see, but you see the general concerns I have.
If you were looking at this record, looking for trouble or concerned that something wrong might have happened, and all that we're looking at is the black and white texture, I see how you get there. But that's why Iowa has historically given this kind of deference to the district court judge. The judge is in the room. He sees the prosecutor. He sees the potential jurors. He can take the temperature of the room, and he can determine whether or not something nefarious is going on, or whether, like we've been talking about, this is just sloppy and ham-handed. I think even just looking at what the court reporter transcribed, this prosecutor was stumbling. This prosecutor was having trouble, and I don't mean to disparage him, but really even communicating where he was trying to go.
But at the point in time when the judge said, overruled and said you can go on, did the judge really understand the crux of the problem that Justice Apple was going into? That the whole case is built upon this missed area of law, and that the officer's going to have to fill in the blanks? I mean, that's something the judge wasn't, or was the judge taking into account at the time, or how do we know that?
The record isn't particularly clear during the exchange from the motion for mistrial, but we do know that the judge sat through the case and then ruled on the motion for new trial, which raises substantially the same issue. If this had been a grand conspiracy by the prosecutor, the district court judge was in the best place to determine that. And the fact that he didn't tells us that he observed this, and he thinks that while this might have been sloppy or it might have come up close to the line, it certainly didn't cross it. I want to shift gears and talk just a minute about where the evidence of prejudice is in this record, because I really don't think there is any. Defense counsel had a lot of opportunities to make a record about potential prejudice. First, she could have at least objected to some of these exchanges that we're talking about. She didn't do that. That tells me that as she listened, she did not think it was problematic. She could have asked the entire panel whether anything the prosecutor said swayed or biased the jury. She didn't do that. She did what I perceive to be her typical voir dire. She could have individually questioned the jurors. She could have asked to do it in chambers. She could have asked to do it at the bench. She could have individually questioned people in front of the whole panel. And she didn't do any of that. I think if we look at our case law, there's no presumption of prejudice.
How do you distinguish this case from Moots, where we said if someone sits on a jury who doesn't belong in a jury, it's a structural error? And I know that was a reverse Batson, but we sort of tweaked our earlier cases where we said if you don't get a preemption, you have to prove prejudice. But there we said if somebody sits on a jury who doesn't belong there, it's structural error.
I want to push back a little bit. I'm not sure that Moots actually did tweak any earlier cases. I think that Neuendorf and Moots, in large sense, can be reconciled. Moots is a very special case. We're talking about the improper denial of a peremptory strike. That's a statutory right afforded to defendants. The court's concern in that case, if you look at the language of the opinion, is what is the remedy if you can't actually prove this prejudice? And the concern there is how would you ever prove prejudice? But here there are a lot of ways. Could have objected, could have questioned the whole panel, could have questioned individual jurors. And I think it's telling that after these exchanges, the prosecutor continued to ask these open-ended questions to the jury. He asked things like, well, does everyone have an overall positive or negative law enforcement? And then on 151 of the trial record, we see that the first juror he asked after these allegedly objectionable exchanges says, No, I have a completely neutral standpoint. I don't really have a bias one way or another. I'm going to look at who testifies and make my decision based on that. So to the extent the record says anything in this case about prejudice, it says that the prosecutor didn't sway anyone. It reinforces what we've been talking about. Is this sloppy? Is it ham-handed? Is it inartful? Yeah, I'll give you that. But is there anything here that is intended to sway or bias or taint the jury? There's just no evidence of that in this record.
How about let's go into the prosecutor's speech a little bit about county attorneys and being elected and accountability and so forth. What was the purpose of that inquiry? I mean, I understand, surely you're legitimately entitled to inquire whether there's bias on law enforcement. No question. That's the purpose of voir dire. If you didn't do it, that'd be odd. But this little speech strikes me as frankly off in the weeds. Elected county official, hold us accountable, that kind of thing. It's almost a trust me argument. We wouldn't bring the charge unless the defendant was guilty, and that, of course, strikes me as far afield. So help me through those issues.
I'm not sure he went as far off course as we might think. Certainly, I think everyone agrees we can ask, are you biased for or against the police? But
sure, but that's not what he's saying. I'm the county attorney. We're elected officials. Did you vote for me? We're held accountable, and all. And as I'm looking at it, I'm kind of going, whoa.
And here's where I think he's trying to get is anyone biased for or against the prosecutor's office? He's trying to suggest that law enforcement includes both the county attorney's office and the police. And
an invitation to hold us accountable through the electoral process, and we've been elected. And my heavens. If you would have asked a straight-out question, which of course would have been perfectly fine, is anybody biased against me personally or anybody in the those kind of things? That would have been perfectly fine. But wow, it's not very close to it, I don't think.
I can't disagree with you. The language is sloppy. That's not how I would have said it. I mean, that's not how I think anyone who is reflecting and not up there in the moment, maybe a little bit panicked at public speaking, would have said it. But I do think that is where he's trying to go. I don't think it's any secret that in this political climate, prosecutors are worried that because someone's watched a Netflix documentary, they might be biased against the police or prosecutors. He's trying to get to the proper question. He's trying to get to, does anyone have a bias for or against the prosecutor's office, the county attorney who's part of the law enforcement structure? His language may have been bad, Your Honor, but it was not bad enough to vacate a conviction and order a new trial when there is no evidence of prejudice.
Well, Counsel, right after that line of inquiry, though, then he sort of suggested that he, as the representative of the state and specifically the county that they should trust, might have some evidence even that he couldn't get in the record.
I see my time is up. If I can respond.
Yeah, would you give us your benign assessment of that line of questioning?
Well, I don't think those words, trust me and I have other evidence appear in there. I really don't even think that's hinted at.
No, he said, and even some of that evidence I may have will not be admissible.
Where are you reading from, Your Honor?
I don't have the page number, but it's from the transcript. And it's shortly after the line of questioning that Justice Apple was talking about.
All I can tell you is if those lines appear somewhere else in the transcript, I certainly don't have them highlighted. There's no objection to that. That's not preserved if it is a concern. I think everyone knows that there's some evidence that's not going to come in at trial. What would concern me is if the prosecutor had said I have evidence the defendant's guilty, you should trust me even though I can't give it to you. That's not what the prosecutor did. What we see is a very clumsy, very ham-handed attempt to get to an appropriate inquiry. And absent prejudice, this court should not reverse.
Chief, could I ask one more question? Again, I think where Justice Heck is going is that he does go into that whole idea of, if you've seen it on TV, we're talking about the concept of relevance, and lots of times there's evidence that the court rules is not relevant and I can't get it in, but there could be other information out there as well. Isn't that pretty much going to or across the line about telling them that, yeah, I may have additional information, then you have to just trust me because I'm accountable to you?
if the prosecutor had made a statement along those lines. And we still don't have any evidence that anything about that statement swayed or impacted the jury. Defense counsel had numerous opportunities, individual or group voir dire. She could have objected. She didn't do any of those things. The point I would urge to this court is that absent any evidence of taint or prejudice, there is no support in our case law other than the exceptional case of Moots, which is entirely different, that would support reversal.
Thank you, counsel. Rebuttal?
Thank you. I just want to point out a couple of things. And we've talked a lot about the questions that the state has asked in voir dire, but I also want to direct your attention and make sure I call attention to the comments that were made. And when the state says, in response to a juror saying, yeah, I have a daughter and son in law enforcement, and he says, well, obviously they're good, hardworking people. That's not a question, that's a comment. That is a statement of that prosecutor's opinion. And when he says correct, and the state says, all right, raised him right. How is that a question? That's not a proper voir dire. And in the appendix on pages 50 through 52, he talks about safeguards so that officers cannot overstep their bounds. I very strongly and strenuously disagree with my colleague's statement that he was referring to himself as some sort of safeguard against himself overstepping his bounds, when he says very specifically it's related to officers not overstepping their bounds, and he itemizes different things, including, and he says, we also have me as the county attorney. He is therefore putting himself out there for this jury as a safeguard to ensure that he has taken steps to make certain that the evidence that the jury is going to hear from the officers has gone through his filter. And very important is on page 66 of the appendix, lines 22 through 24. The trial court actually says exactly what I've said. He says, Sue Flander, you fix it. I'll leave it to you to fix it in your voir dire. And he says on page 67, lines 1 through 4, he doesn't want to say anything else because he might make it worse.
I'm looking at that, and I don't quite have that take on it. It seems to me he's saying it's not, what happened is not prejudicial. Whatever concerns you, I'll leave it to you, Ms. Flander, to address whatever concerns you have about the state's voir dire as you proceed in your voir dire.
Right.
I don't think that's saying you have to fix. I don't think he's saying there's a problem you have to fix. I'm saying to the extent, I think he's saying to the extent you think there's a problem, go deal with it in your voir dire.
Well, I think that either way, he is telling Sue Flander that the burden is hers to fix voir dire, which is not one of the two reasons that the defense should be conducting voir dire.
Don't you think there's just kind of the overwhelming impression is one of clumsiness and of someone who probably offended jurors as much as he convinced them?
No, I don't. I see this as an absolute trial strategy that flowed from the beginning to the end of this case. And it's clever, and it's pushing the boundary, and when the Court of Appeals says, yeah, it teetered, but it didn't cross, it basically says to everyone else, yep, approach, teeter, and then if you do cross...
I mean, he gets a lot of names wrong. I mean, everybody does that. I did that. And I noticed at one point he asks a woman, is questioning a woman, finds out that she has some young children, then 10 pages later he asks her if she's married or not. I mean, isn't the impression that this is just kind of an awkward effort?
Not at all, because I read this case, and if I ever were to become a state's attorney, I would say, hey, I didn't cross because look, this guy didn't cross. I didn't even come near that line, and if I did cross the line, I didn't cause any harm, so no harm, no foul. And I think that is the wrong message to send to state's attorneys for certain, but definitely don't let defense counsels down like that. Uphold the integrity of the voir dire process. We need it. We have to rely on it.
Do you think the trial judge missed the cleverness that you're describing?
No, I think that the trial court, like like the state's attorney said, Mr. Norman said, let's not waste anybody's time here. Let's not waste anybody's time. I mean, we've come this far. And he says that in his initial statement to the court that, well, even if I did make a mistake, we don't want to waste everybody's time here because it's expensive. And I think that the trial court, if anything, was relying on the expertise, as he says on page 66, lines 22 through 24 of Sue Flander to make it right. This is strategy, Your Honors. It is strategy, and it is wrong because those two cases don't say that this strategy is an appropriate one. It says help the court get enough information to properly exercise your peremptory challenges because we want justice. We want a fair jury system. That's what this case is about, and it matters. Eyes are on it. I don't know. I think clock is going up, so I'm over. Okay, excuse me. Thank you.
Ms. Reindl, thank you. The case is submitted. We'll now hear the arguments in Estate of Paul or David Paul McFarling.